assessments. And so,
over the age of 65, but also younger and have very chronic or have very serious chronic diseases. So what you have in front of you is a folder, and this folder was scientifically designed to hold your estate planning documents because everyone was asked, well, where's your will? Oh, I don't know. So now you have a folder, and nobody has safe deposit boxes anymore, or if they do, it's like, oh, what bank was that in? And I don't know where the key is. And the reason is that houses don't burn down the way they used to because we have professional fire departments. Also, people used to accumulate wealth in gold and tangible things. And now, you know, someone will tell you they have gold, and what they really have is shares of gold held at Solomon Smith Barney. So mostly people keep documents in their home. And in this folder, there is a lovely booklet that we have literally rewritten hundreds of times to keep it current. And it's basically estate planning 101 with a slight emphasis on long-term care. Did you get a folder? Oh, geez. With a slight emphasis on long-term care and just a teeny bit about inheritance taxes. If you did not get a booklet, they are over here. And thank you. Yes. Also, there's a free pen, and you know we originally hoped that we'd go to the Supreme Court and that be worth something. But it hasn't worked out. Okay, so first I thought I would touch on just a couple of things that came up earlier, and somebody asked, well, is someone like an elder advocacy organization that's providing home services going to be an advocate for the individual? Well, that really would put them in a conflict of interest because they are the provider and the advocate. And that's a really tough position for them to be in. Really, to the extent that an individual needs an advocate, they have to advocate themselves or appoint an advocate. And what I have found with home health care agencies is that they're immensely experienced about things that, say, people whose last names are followed by MD are clueless about. Because the people whose last names are followed by ND or DO see you for 20 minutes and it's, you know, welcome in, welcome out. Those people do it 24 hours a day or at least in 8-hour shifts, and they are immensely helpful. And so, for example, when they go to appointments with an elderly person, they can really ask the important questions. But it's very hard to put them in a position of advocacy. So who should be in a position of advocacy? Well, that's a good place to begin. In fact, everyone here, comma, and here comes the free legal advice, comma, everyone here should have at least 2 documents, legal documents. The first is an Oregon Advance Directive, not the post, not the power of attorney for healthcare, not the mental health directive, not the directive of physicians, not one of the many other Oregon legislative attempts to find the perfect balance between, you know, what you want and what the legislature is willing to pass. And that perfect balance is the Oregon Advance Directive. You can get it from your provider, you can get it from Google, you can get it from any number of agencies. And that document does 2 things. Number 1, it says, if I cannot make healthcare decisions, this is who I want to make them for me. Or if he or she cannot, then this is who I want. So if you think about it, that's kind of a power of attorney for healthcare, even though it's not called that. Secondly, the document says, if I am in one of these very, very crummy end-of-life situations, and 2 doctors verify that I am in one of these situations, then I do or do not want heroic measures. I do or do not want tube feeding. I do or do not want life support, other life support, such as a respirator or a ventilator. Both those things, the power of attorney part, naming someone, and your wishes in end of life, in one convenient document written by the legislature that you don't need to go to a lawyer for, and everyone needs one. And then that document has to be given to your medical provider and your spouse and your kids, and if you don't have spouse and kids, your sisters and your brothers and your aunts and your nieces and nephews are gonna step into, or your friends or your lover or whoever. Everyone needs to have a copy of that so that, one, they know who has to step up to the plate, and two, they know whether or not you do or do not want heroic measures. Now, is there a reason to go to a lawyer for it? Yes, there are some sort of out-of-the-box situations where you might want to go to a lawyer for. So you'll notice that the standard document names A and then B. What if you have 3 kids and you want to name all 3 of them? It's kind of difficult to put in A, B, and C where it just says A and B. Well, you can fidget the form, but now it starts looking a little less strong. Or what if the people who you are naming and you are so philosophically opposed to your heirs, your kin, your mom, your dad, well, maybe it's worth going to, and you see this with same-gender couples, where there's a huge discrepancy in philosophies. So then maybe you want to go to a lawyer because it makes it a meatier document. Meatier as in meat, red meat. But on the whole, you don't really need a lawyer for it. Why is it better than the Post, which everyone loves? Everyone loves it because it's a pretty color, and everybody loves it because, wow, you just fill in 3 blanks and you're there instead of having to thinking about all this. Well, a Post, if you think about it, is physician's orders for life-sustaining treatment. Physician's orders. So you have to be under treatment. It's the physician's orders, not who I want to make decisions in 5 years when I end up getting kicked in the head by a horse. It's physician's order. So Post is brilliant when you are under treatment and you need physician's orders to be made painfully clear and duct taped on your chest or put on your refrigerator. But for an advance directive, the Oregon Advance Directive. Were you an asshole? Oh, okay. No, that's not bad. So everyone should. So that would be your advocate if you cannot advocate for yourself. And now a lot of people will say, "Oh, the doctors don't pay attention to those." Well, to be honest with you, the doctors pay attention to them if the person you named will be your advocate. They don't have any choice. In my experience, it's kind of gone the other way. If I have an elderly person with some dementia or not an extraordinary amount of sophistication, and a very able advocate, frequently the medical provider will disregard the elderly person because it's just easier to have that repartee, particularly if you only have 23 minutes, with that other person. So we can't use this document to overstep our authority. So any questions about that? Sir?
I've had terrible problems in the past. My mother died 12 years ago, and 2 years before that she was in intensive care with a heart attack. In the intensive care unit, she was sort of forced by doctors and nurses to do it. I'm sure she had it before. I mean, she was in her 90s, and so she had done this form before, and so they forced her to do it. She was, scared to death. She was getting close to dying, though she didn't. And it was very unfortunate. And I explained to them, this is something you ought to do with the doctor and explain to people. And so 5 or 6 years later, she did die, and she died at home. And my father called 911, and they completely disregarded it because his main thought was he wanted her to live. And I'm sure she had no idea what was going on, but it was very unfortunate.
You mean, so she signed something saying, "I want no heroic measures"?
Correct.
Yeah.
Correct. And the EMTs did.
So,
which is neither here nor there because my father was happy that he had done everything he could to save her life.
well, I hope that you were there to help sort things out a little bit, because the reality of the matter is, things don't work.
Not right.
Right? I tell people, I can have this witnessed by the Archbishop of Canterbury, the Pope, and the Rabbi of Warsaw, and it still may not fly. That's just going to happen. And then you have to be the good advocate or hire the guns to be the good advocates. But sometimes, and I've heard every story I recently had a client come in, unbelievably confident. What he's paying, like $20 million by the time they were 35. So practicality was not something he was failing. And his dad in Atlanta was very unhealthy, and my client met with the physician outside of the presence of his father and handed him an advance directive of some sort that said, I don't want heroic measures. And this is the story I got, literally. The doctor picked it up, looked at it, ripped it up, put it in the trash can, and said, we don't do this around here, and if you call up the sheriff, they'll stand by me.
Wow.
Okay. So don't fly through Hartsfield Airport. I believe that's a true story, and he told it to me, it's a true story. So things are gonna go awry. You have to do the best that you can do.
Well, I got to the point where I felt it's not just a document, it's an understanding between the people who were concerned. So it was an understanding between my parents as to what they wanted to have done, and I'm sure they didn't really. They may have talked about it a little bit, but there was no clear understanding between them that if something was to happen to one or the other, this is what was going to happen.
Yeah.
I mean, it's sort of. I mean, I think, they were both in their 90s, and it was very difficult for them to want to have to talk about the fact that the end is coming, and we need to really face the reality of what happens if something happens to one of us.
Another issue is that part of your story occurred in the emergency room. And I've always posted this hypothetical. You fill out a document that very clearly says you don't want any heroic measures. You walk out there, you tape it across your chest, facing out, and you fall flat on your back with a huge aneurysm, a massive embolism, something. An emergency person shows up. What are they going to do?
Say something.
Well, I don't know. I don't know what they're going to do. But frankly, if they treated you in that emergency, hypercritical situation, and you came out of whatever problem you had, you'd say, thank you. And so it's still unclear how often these things work in truly emergency situations. That's very different than my mom, who's 91 and can barely get around her 800 square foot apartment, et cetera. So there are always going to be situations where it's not perfect.
But
Yes.
technically, would they apply in the context of the EMT through the harassment?
I think technically they're not supposed to treat you, according to medical providers I've chatted with, but
Yeah.
I haven't. But on the other hand, you know that if they don't, somewhere out there, someone's going to sue them for not doing it. So,
But in my situation, my father didn't have the document handy. I mean, I'm sure he probably wouldn't have even known where to go to get it. It was someplace in the house, and he never said anything to me.
Yeah.
So they didn't know.
absolutely, and there was
And
there was a Robert
he
Woods
was not
Johnson.
concerned about that. He was more concerned. He kept saying it. He wanted her to live.
Yeah. There's a Robert Woods Johnson Foundation study that's either back in the 80s or the 90s when these things weren't as common, and it had a control group and then a group where people had filled out these directives, and they found the single biggest factor was how good an advocate was the person, not whether they filled it out. So people who hadn't filled out any directive but with a good advocate got the positive results, whatever those might be for them, compared to bad advocate. And so interestingly enough, people who were minorities were dreadful advocates because they're used to not getting anything they ask for, and they're used to being sort of put to the back of the line. So that was like a huge dynamic, whereas, college educated, et cetera, people who were willing to look at a doctor in the face and say, I knew people like you in undergrad, and you're not as smart as you think you are. They were great advocates. I'm poking fun at doctors, I hope that's okay. Sir?
Speaking of advocates, I got a bunch of flaky relatives.
Ah.
I don't want them to be advocates. And
Yeah.
I don't want to hurt my friends or call a Elders in Action personal advocate.
Yeah.
But a lawyer or someone else, who would make a good advocate?
Well, so lawyers are not allowed to suggest themselves as advocates. We're not allowed to put ourselves in the will as executive. We're not allowed to. But if you ask us, we can. And I will tell you that in our office, we typically will, for financial things, successor trustee, et cetera, settle the estate, but not so much for healthcare reasons, because that's not where the strength of our training is. So what we will do is we will refer you to professionals who do act as advocates and make a living out of it. Those folks, it's a whole little industry that has evolved because, you know, historically in the United States, bank trust companies have done kind of that sort of work. But bank trust companies have huge overheads, so they require a certain level of asset base to take on a client. And I actually think they do a great job. It's just that they have a lot of overhead, you know? So in Oregon, as in many other places, a group of people that are willing to take on smaller estates, smaller cases exist, and we can put you in contact with them. But that's not a perfect solution because, you know, what if they retire or their spouse moves to San Diego or something like that? And so I would posit to you the following. If you cannot rely on flaky family, do try to come up with a group of friends who are willing to do this, and don't think of it as burdening them. I know what you mean. I mean, you don't want to ask your friends too many favors, but I think that, you know, in some sense, it's also an honor to be asked to do these sort of things, and a lot of people will take it as an honor. I have a lot of people that are friends that are named, and not a lot of people who come back later and say, I don't want to do it. That just occasionally happens. Now, of course, you have to have that conversation in advance, but don't think of it as a burden. And then it can also be reciprocal. I mean, if you remember back when you were 30 and had your first kid, the discussion with your friends or cousins or sisters about who would be guardian for, you know, your new kid, if you couldn't be, and the same concept, you know. I don't want to burden them, you know, but the people were willing to step up to the plate, right? One more question, Miss.
I have a couple of questions about the advanced interactive.
Yes.
And, you mentioned that we don't have to look for a lawyer unless it's in a specific case.
Yeah.
But how do we validate the advanced interactive? Do we need to notarize the signature?
Yeah, so the documents that you get identify the process for executing it validly. And then what they probably also say is make sure that everyone gets a copy. But it must be witnessed by two people who are not named in the document and who are not your medical provider, hence the conflict of interest of having a medical provider as an advocate.
Yes, a little bit more about the advanced interactive.
Yeah, one more.
Okay. So if a person finds a relative, for example, to be the person to take care of that,
Yeah.
that person has the right to decline. I don't want to be I don't want to be responsible for to make decisions for you. So
Yeah.
if the person declines, and how does it work? Because I was comparing,
Well, it goes to the next person in line. So, but it's better to have a conversation with them before they decline, right? I mean, you have to have that conversation up front because it's a lot of headache to get the document, to, you know, find the witnesses, and then you send it to all your doctors and, you know, your brothers and your sisters, and these people say, I don't want to do it. So you have that conversation up front. If later they decline, it goes to the next person in line, and it is conceivable that a medical provider will ask for the written declination by the first named person. Okay, one last question.
Well, just on that point,
Yeah.
the designee, don't they have to sign the document?
Yeah, they have to accept.
Yeah.
Yeah. Yeah. Okay, so I said that you need two documents. That is the first. The second is a financial power of attorney. Now, I don't actually know what each of you has done in your advocacy and volunteering, but I will bet good money somewhere along the way you heard that powers of attorney are a dangerous document because people use them to steal money. And just this morning, I was reading the Oregonian, and it turns out some elderly guy in Gaston, and his even more elderly father, got, if you'll pardon my vernacular, ripped off for something like millions and millions of dollars by a couple of questionably good-looking lasses that have been involved in their lives. Now, the Oregonian being the Oregonian, there's no details. Like, you have to guess everything. But nonetheless, I'll bet a power of attorney played something to it. It might not have. They might have become trustees, they might have become joint owners on accounts, they might have just had computer authorization, because there's so many ways to steal, really. And powers of attorney tend to be a bad culprit. In other words, someone goes down to Stephen's Nest, the legal stationery firm, gets a form, you know, and they've got this neighbor who they've lived across the street for 17 years, and the neighbor doesn't seem to have any actively involved family, and they've been talking about, hey, you know, I can help you, Joe. You know, and Joe signs, they go to the bank, Joe signs a power of attorney, and it sits there idle for a month or 3 years, and then all of a sudden, what do you know? Money is moving out of a bank account, or the power of attorney is being used to change the beneficiary on an annuity or something. They just have a bad reputation. Having said all that, they're also brilliant documents and very important, and you should have them. And what is the difference between this horrible document and this brilliant document? It is who you name. Don't name the last that all of a sudden thinks you're really good looking, even though you're, 143 years old. You have to name people who are completely trustworthy. And if they're not completely trustworthy, it doesn't work. Now, fortunately, after doing this for nearly 30 years, I've discovered that most people have completely trustworthy people in their lives. In my case, I have a wife, and I have 2 kids who are not at great ages. 18 and 21 are not the ages at which necessarily I would appoint them. But they'll get there as soon as they get all that fuzz out of their head. And then in the absence of them, I've got a great sister, and I've got 2 great half-brothers, and but not everybody is lucky enough to have that. So you have to find folks. And then you appoint them, and you put that power of attorney in a safe place, which can be this wonderful folder, or your safe deposit box, or your gun safe, or wherever you choose to put it, and hopefully it will never be necessary. But if you lose the ability to process information due to Parkinson's or Alzheimer's, or someone my age, massive stroke, heart attack with oxygen deprivation, mistaken driving on the way back from the coast, all the multiple reasons where one can have the inability to process information. If there is no financial power of attorney, how does one's loved ones start applying for disability insurance, file taxes, access the IRA, which is in my name alone, access the 401k, which is in my name alone, sell the house, which requires 2 signatures to sell it, refi the house to a lower payment because it's too expensive since I'm not working anymore. All those things require me to sign. And if I don't have the cognitive skills to sign, it has to be my power of attorney. And my power of attorney will be able to get the job done. And if there is none, then my wife, our loved ones, have to go to court to declare us incompetent. And that means that all of our financial affairs from that point on are managed through the court system. And anyone here who wants to have their financial affairs managed through the court system with a bond and lawyers full-time, raise your right hand. Nobody wants that. It's quite expensive. It works really well. It is the most supervisory way of doing it. But if you can name a trustworthy power of attorney, then you can avoid that. Now the flip side is, say that I can't find a trustworthy person. And let's say that I do have that medical event that renders me unable to manage my finances. Then someone, a sure-tail family member, a friend, maybe a professional, maybe DHS, the state agency, maybe the public guardian, if I don't have a lot of money, will file to manage my affairs.